Okay, everybody, why don't we get started? We have a number of people in the room and a larger number of people on Zoom, and I just want to welcome everybody. My name is Daniel Kanstroom. I'm a law professor here at Boston College. I teach human rights law, immigration law, sometimes constitutional and administrative law. And I'm a co-director of the Center for Human Rights and International Justice here at Boston College. And together with my co-director, Professor Brenton Likes, who unfortunately cannot be here today, and Tim Kars, our assistant director, it's my pleasure to welcome you to this event. Oh, Brenton is online. Thank you. Hello, Brenton. Always here with us in spirit and now on Zoom. This event is a very important contribution to a series of many events that we've had on the evolution of human rights, different aspects of human rights, and our focus today in particular is on LGBTQI rights in the inter-American system. So it's both a focus on a particular area of rights discourse, which has been very dynamic, very important, and very evolutionary in the last couple of decades. And it also puts a spotlight on the importance of regional human rights systems. We do a lot of work with international human rights. In some areas of law, the development of rights in regional systems has been really quite profound in the realm, for example, of migrants' rights that I'm familiar with. The contributions of the Inter-American Court, the Inter-American Commission, the Cartagena Declaration going back more than 30 years have been profoundly important. And I think we're going to hear that a similar phenomenon may be true in the Inter-American system now. So we're very lucky to have a fantastically qualified speaker who has generously agreed to appear on Zoom from Brazil. I'm going to do a very brief introduction. She has an enormous resume with many accomplishments, so I apologize. I'm going to keep it brief because I think the substance is more important, and we have posted her bio, I hope, on our website so you can see it from there. Before I do the short bio introduction, I want to say that we are going to have to end at 1 p.m., although for people in the room, we can stay here and talk a little longer if people want to do that. We're using the Q&A feature on Zoom, so for those who are viewing on Zoom, please use that to pose your questions, and then I guess, Tim, you'll curate questions as we go from that. So we'll take some from here and some from there and sort of go back and forth. I want to tell everybody, because it's required by Massachusetts law, and it's also the right thing to do, that you are all being recorded. We are all being recorded, just so you know. If you have an objection to that, now's the time to take your lunch and go. Okay. Flavia Piovesan is a professor of constitutional law and human rights at the Catholic University of Sao Paulo and in the human rights postgraduate programs of the Catholic University of Sao Paulo and the Catholic University Paraná. She also teaches human rights at PhD program of the University of Buenos Aires and at the American University Washington College of Law, where I don't know if you know this, but I taught there too about 10 years ago. I don't think we met then, but maybe we did. She holds a master's and a PhD in constitutional law from the Catholic University of Sao Paulo and has been a visiting fellow at the Human Rights Program at Harvard Law School and at Oxford and at the Max-Planck-Institute and many other places. She is really, really an expert on this and many other human rights subjects, and we're just honored to have her to present for you today. So let me turn it over to you, Flavia, and then we will have ample time for questions and both live and from Zoom. So welcome to Boston. Thank you.
So thank you so much, Professor Daniel. It's an honor to be here. So let me start with three feelings: the feeling of deep gratitude, expressing how happy, delighted, and enthusiastic I am to dialogue with you about lights and shadows of LGBTI rights, human rights in the Americas, and all my experience at the Inter-American system. A word of recognition. So congratulations for the remarkable work that you developed at the Center for Human Rights and International Justice at the Boston College. Then a word of hope. I think, as my close colleague, Catherine Sicking, always stress, we need sustainable hope to feed the struggle for rights and justice. So it's an honor to be here, and I'd like to express my deep thank you to all of you, but especially to Daniela, Tim, and my dearest colleague, professor from Brazil, Pedro Lenza, who I just met, I had the pleasure to meet a few moments ago. And thank you as well to all the institutions who which are co-hosting this event, the Boston College Latin American Studies Program, the Boston College Organization for Latin American Affairs, and the Boston College Law, the Law Student Association of Latin American Students. So I feel really happy and honored. My talk today will focus on two central questions. First, what has been the transformative impact of the Inter-American system and the protection of LGBTI rights in the region? And the second question is, what are the main challenges and perspectives to strengthen the protection of LGBTI rights in the region? So I'd like to start with the first question. What has been the transformative impact of the Inter-American system in the protection of LGBTI rights in the region? So I'd say that the Inter-American system saved and has saved many lives. It fosters the destabilization of dictatorial regimes, demanded justice and an end to impunity in democratic transitions, and demands the strengthening of rule of law, democracy, and human rights, combating human rights violation, and protecting the most vulnerable groups. I remember a mantra that we used to repeat is that our transformative mandate has the ambition to protect rights and to change realities. So giving voice to the voiceless, give visibility to the ones who are invisible. So we have this emancipatory potential of the Inter-American system. And here, to be honest with all of you, and to be fair, I'd say that the transformative impact of the system in the region results, above all, from the vital role played by civil society organizations. I would say that NGOs and victims are the oxygen of the Inter-American system in its struggle for justice and rights. So I would say that the Inter-American system, I think, plays three important roles. First, to establishing human rights standards. Secondly, compensating national deficits. And third, fomenting a new dynamic of power among social actors. So in this sense, the Inter-American system contributes to the strengthening of democracy, rule of law, and human rights. And I'm honored to share with you my experience. I had experience to serve the Inter-American system as a commissioner and as a rapporteur for LGBTI rights from 2018 to 2021. So 4 years of experience. The first idea about the Inter-American system, I'd say it has three dimensions. First, the victim-centric approach. So this is, I think, the core of the system, the soul of the system, which deals with human suffering and the need to provide effective remedies to safeguard human dignity and to prevent, as I said, human suffering, paying special attention to the persons and groups facing special vulnerabilities. In addition to this victim-centric approach, we have the Inter-American standards, which is a second important dimension. There is an Inter-American corpus juris jurisprudence, and I do believe that this corpus juris is key to compensate national deficits in the region. And third, the idea that is very innovative in the Inter-American system, the so-called comprehensive reparations. For the Inter-American systems, structural violations, human rights violations, have structural causes. And the transformative mandate of the Inter-American system has this goal to dismantle the structural causes, which implies structural human rights violations. So just to make it clear, when you think about comprehensive and the Institute of Comprehensive Reparations, we demand from the state measures of different nature, such as the payment of economic compensation, to investigate, process, punish perpetrators, adopting due diligence, to adopt structural changes in the name of guarantees of non-repetition. So adopting new public policies, new legal framework. So I think this is, those are the three essential dimensions of the inter-American system. And as a rapporteur, a former rapporteur for LGBTI rights, the mandate was inspired by, I think, the human rights approach. So as I mentioned, the inter-American standards, the Corpus Juris, highlighting the universality, indivisibility of human rights, this holistic approach combining civil and political rights and socio-economic and environmental rights, and then I highlight intersectionality. This is very important to have, for example, disaggregated data. In now all our reports, I do remember I was at the UN and at the Permanent Council of OAS presenting a report 2019 about recognizing LGBTI rights in the region. One of the key recommendations addressed to states was exactly to provide disaggregated data. So I would say that LGBTI community is not homogeneous. So some LGBTI people could be more vulnerable than others due to other multiple criteria and intersectional factors such as race, ethnicity, age. And I do learn, and this hurts me, all the public hearings we had about this topic, the peculiar situation of trans women in the region. Can you imagine that trans women in the region, the life expectancy is 35 years, whereas my life expectancy in the region is around 80, 85 years. Trans women, again, they live approximately just 35 to 40 years, less than half, because of the culture of strong pattern of cruelty, discrimination, and violation of those rights. And as well, because I worked a lot intensely with the UN, with my colleague, Vitor Madrigal, who is the independent UN expert for this topic. And I'd like to quote him, because he said that LGBTI rights face three key challenges: demonization, criminalization, and pathologization. So being LGBTI, or, expressing a kind of sexual orientation which is not confined in the binary logic, is seen mostly as a sin, as a crime, or as a disease. So that's the view that we have. And the flag is the UN Declaration, when it states that all human beings are born free and equal in dignity and rights. And as a commissioner, I was always stressing the right to be, not more nor less, but the right to be. Meaning, all of us have the right to give meaning to our existences through our choices, our values, our convictions, as our Inter-American Court so beautifully stated in the advisory opinion number 24 in 2017. So we, at the Commission, we concentrated our mandate in three strategic areas. So we have three priorities. First, to combat violence based on sexual orientation and then gender identity. ensuring the right of everyone to be free from violence, and it states the legal duty, the legal obligation to prevent, to investigate, punish, and provide reparations for violence based on sexual orientation or gender identity, adopting all necessary measures, all due diligence. As a commissioner, that's the way I'd say, that's the rationality. If there is the right, on one hand, to be free from violence, this right, as a result, as a consequence, demands legal duties from the state. So here I'd like to mention our report on violence against LGBTI persons' rights of 2015 is being updated by a request of General Assembly of the OS. And one of the conclusions of this landmark report is that Latin America has 80% of the world's population, but accounts for 38% of the world's homicide. So it's the most violent region of the world, and the region with the highest number of reported cases of violence against LGBTI persons. Plus, something that I learned, the brutality is not just to violate the right to life. It's not just to commit a homicide or a murder, but always there is this component of hate. So the crimes, for example, faced by trans women used to be particularly cruel with high levels of brutality. So LGBTI rights are LGBTI persons are subject to various forms of violence and discrimination based on their sexual orientation and gender identity. Here I'd like to mention two landmarks, two cases decided by the Inter-American Court. One was case Azul Rojas Marin versus Peru. The sentence was granted in March 2020. Was the first case before the Inter-American Court addressing violence against LGBTI rights persons in the inter-American system. The case related to the illegal, arbitrary, and discriminatory deprivation of liberty of the victim, at that time a gay man, and he suffered serious acts of physical and psychological violence, rape. And what is interesting, reading the decision, is that regarding guarantees of non-repetition, the court demanded Peru to adopt a specific protocol, to investigate cases of violence against LGBTI rights. Also, the court requested Peru to provide capacity building to state agents about violence against LGBTI rights. Also, to produce statistics and disaggregated data, and so on. So this was one very important case. And another case that I'd like to mention is the case Vicky Hernandez against Honduras. I had the honor to represent the commission before the court in this case. This was a brutal and a dramatic case of this activist, human rights activist, trans woman, who was dramatically and brutally killed in Honduras, suffered extrajudicial execution, and then again, in the name of guarantees of non-repetition, again, the court demands the protocol and demands the investigation and capacity buildings, and also psychological treatment to the family. And this was a remarkable case because for the first time, the commission argued before the court that the Inter-American Convention on Prevention and Eradication of Violence Against Women should be applied to all women without any kind of discrimination, including trans women. And the court, by majority of votes, endorsed this view. So this was a remarkable case, and the decision was granted in 26th of March 2021. I do remember as well, I'd like to highlight, with the special rapporteurship of economic, social, cultural, and environmental rights, jointly we adopt a report on trans persons and economic, social, and cultural rights. And again, according to the data collected, trans women killed were 35 years old or younger due to this brutality, due to this violence. The priority is to combat discrimination based on sexual orientation and gender identity, ensuring the right to be equal, and demanding, on the other hand, the state obligation to prevent, investigate, punish, and provide reparations for discrimination based on sexual orientation and gender identity. So the system demands the states to enact anti-discrimination legislation, to enact gender identity laws. And here, the most emblematic case was Karen Atala and Iras against Chile of 2012. This was the first emblematic decision regarding LGBTI rights. So 10 years ago was the first. Then we had another case against Colombia, Duque versus Colombia, 2016, Flor Freire versus Ecuador, 2016. And here the court adopted 4 arguments. First of all, this is key for the inter-American system. Equality and non-discrimination is a jus cogens, a peremptory norm. Second, the clause of equality and non-discrimination is an open clause, embracing sexual orientation among other criteria. So sexual orientation and gender identity could not be a criteria to reduce, to diminish the scope of rights. The third argument, protection of privacy, autonomy, and freedom. And fourth, a pluralistic view and concept of family, not limited to any particular structural model. In the words of the court, the Inter-American Court established that the sexual orientation of a person is a category protected by the American Convention. Although not explicitly, the convention was adopted in 1969. Therefore, any regulation, act, practice considered discriminatory based on a person's sexual orientation is prohibited. Consequently, no domestic regulation, decision, or practice, whether by state authorities or individuals, may restrict the rights of a person based on his or her sexual orientation. So then we have the advisory opinion 24, about protection of gender identity rights and same-sex marriage. That was one of the priorities of the rapporteurship, to make the diffusion of this, those standards. And also, again, I'd like to quote the court when it says that all human beings have the right to give meaning to their existence according to their own choices and convictions. And it's amazing to see the impact that this advisory opinion had in the region. I had the honor now in Brazil to be a scientific coordinator of a unit at the National Council for Justice. We just adopted this book. It's a book about LGBTI rights in Brazil, collecting the key decisions of our Supreme Court in Brazil. And we identified 10 leading cases. 9 out of 10 are based on the advisory opinion number 24 issued by the Inter-American Court. So we had a decision given by the Sala Constitucional from Costa Rica, which also was based on the advisory opinion in August 2018, ordering Congress to adopt a law guaranteeing equal rights to same-sex couples. We had, as I mentioned, in Brazil, a number of decisions about gender identity rights, combating homophobia based on the advisory opinion. In Chile, as well, in November 2018, a bill was approved to protect transgender rights, gender identity law. In Uruguay, we have the the comprehensive law for trans person, is a role model for the region based on the opinion. In Ecuador, June 2019, there was a key case about equal rights for equal marriage and same-sex marriage based on the advisory opinion. And finally, the third priority is to foment a new culture based on the respect of human rights for all and promotion of human rights. So we do believe that it's important to have new legal frameworks, new laws, new public policy, but we have to change the culture, and this takes time. So cultural change is fundamental educational policies. So I think the Commission is ready to approve a report about the cultural transformation and educational rights and LGBTI rights. And I'd like to end up with my last question. I'll give myself 5 minutes, the last. What are the main challenges and perspectives to strengthen the LGBTI rights in the region? Here I'd like to conclude briefly focusing on 3 challenges. First is criminalization. So still in the world, we have almost 200 countries, 67 is still criminalized LGBTI persons. In the region, out of the 67, 6 are in the region. Antigua and, Dominica, Grenada, Guyana, Jamaica, St. Vincent and Grenadines, and Santa Lucia. But we have empirical reasons to have hope. When I took the position of a special rapporteur for LGBTI rights in January 2018, at that time, we had 11 in the region. And now we have 6. So this, I'd say that we have empirical basis to be hopeful about that. The Commission considers that there is a strong correlation between those norms which criminalize and violence against LGBTI rights persons, because those laws send a social message that discrimination and violence are tolerated. And there is, just to mention the case of India, there is a very interesting report about done by the World Bank on the economic cost of homophobia. So embracing depression, suicides, and cost of exclusion. And at that time, the criminalization of LGBTI rights would cost 1.7 GDP in India, which corresponded to 30.8 billion. So there is this economics cost. And I do remember with Victor Madrigal, we had a project of incidents in the Caribbean region with Commonwealth. We were there in Barbados before the pandemic to address this issue in the framework of No One Left Behind, the UN 23rd Agenda. The second challenge has to do with populism. Far-right populism. If we do a research about the populist narrative, the far-right populist narrative, as the former president of the US or the former president of my country, you see many similarities, a kind of authoritarian and homophobic and transphobic conservative narrative. This, of course, hate speech can kill, especially the ones who are in power have enforced responsibility. And it's amazing to see in my country how when the president of a nation has this narrative based on hate speech, a homophobic, a transphobic narrative, this fosters violence, discrimination, and hostility against LGBTI rights. So there are statistics showing that the number of violation of human rights increased tremendously in the last 4 years. And the third is conservative religious groups, or the so-called anti-rights movement, with this argument that freedom of religion is affected by LGBTI rights. So I remember we had at least 3 meetings at the OS about this topic, and our view is that equality and non-discrimination is jus cogens. So this is the starting point of any conversations. And so I'd like to end up just saying that, and quoting here Habermas, when he reminds us that the origin of human rights has always been resistance to despotism, oppression, and humiliation. And he also added that the human rights constitute our realistic utopia in building more inclusive, democratic, pluralistic, and egalitarian societies, in where all human beings can be free and equal in rights, respect, and dignity. But I do believe that moral revolutions happen, and the answer is simple: because of LGBTI rights movement, their devotion, their braveness, their resilience, their resistance, their creativity, their audacy and irreverence, I would say as well, nurturing the question for social change with anger, hope, and believe that we all can make a difference. Thank you so much.
Well, thank you, Professor Flavia. That was, if I may say, very moving and inspirational and incredibly well organized and on time and focused. And you just covered an enormous array of important topics. And I just hope there are many students watching who can understand the power of the human rights idea, the evolutionary power of it, the protective power of it, and the engagement point, the relationship between activism and scholars, that these are not abstract things. And I'll just say for my part that I hope that you're right, that we're witnessing a dynamic movement in a progressive direction. It looks that way in Latin America. In this country, we're fighting a rearguard action on a lot of these issues, as you know, and we'll see what the Supreme Court is going to do. There's a struggle of which direction the law is going to go in the United States. Let's open it up for questions. I imagine that people have many questions, and let's start with people in the room. And
so, Flavia, my question is about. Okay, great. We saw in US, you talked about some cases that were decided by the Supreme Court, and I would like to remember the case of abortion. So we have the landmark case of Roe that was overruled in 2022 by Casey. And this decision of the US Supreme Court was that this right was not established in the US Constitution. So the states, they were supposed to establish the rules about abortion. And after this decision, we saw a big movement on the states, some trigger laws that were passed. And we saw at the end of last year, the rule that was passed by the Congress that established the right of abortion, even if let me start again. So we saw the decision of the abortion and the impact on this state. So my question is about the same-sex marriage and the interracial marriage. So we have two landmarks of the Supreme Court that establish the right of same-sex marriage and interracial marriage. And this is the law that was passed by the Congress last year that established in the national perspective the right of same-sex marriage and the right of interracial marriage. So-
If recognized by one state, that it has to be recognized by other states.
Yes, very good. Yes, yes. Even if the state, they have to recognize. So we have this law that assecurate any challenge of the Supreme Court. And we know that the Supreme Court changing in US and also in Brazil. We have a very conservative Supreme Court in US after 3 nominations of the former president, and also in Brazil we had this. So my question is, in Brazil we have decision of the Supreme Court that assecurate and establish the same-sex marriage. My question is, if we have a change of the decisions of the Supreme Court, and we don't have in Brazil and other countries the law established by the Congress, different than what happened here, how can the system, the international system, fight to keep those rights, even if we have a change in the Supreme Court and we don't have the law passed by the Congress? So how can we enforce and protect those guarantees that was established by the Supreme Court? Sorry for.
Thank you. Thank you.
Okay, thank you.
May I? Professor Daniel?
Please, please.
Sorry, what is your name? The name of the one who made the question?
That was Pedro.
It's a very, very fascinating question. So I would say I have 3 ideas, 3 thoughts. First, I love the idea of lights and shadows of LGBTI rights, human rights in the Americas. That is the title of my talk, because for me, human rights are made by shadow and lights. We do not have a linear perspective, but we have shadows and not lights. We have sometimes achievements, sometimes regressions, backlash, and that's the way it is. It's such a complex, multidimensional, dynamic history of struggle and justice. So this is the first point. The second, it was very, very interesting that you share the situation, the case of abortion and the case of same-sex, because as you mentioned, there was the Roe v. Wade of 1973, and there was this devastating decision of 2022, but then you have the federalism. And as you mentioned, I was following, and Professor Daniel, I don't know if it was Kansas, there were even states, surprisingly, Republican states, which approved, which guarantee abortion for women. So it's interesting to see, I'd say, the dynamic of checks and balances, considering federalism and the separation of power. So in the US, I'd say you had this federal approach in a very deep way. And as you mentioned, we have different voices of different states, and you have also the legislative branch. In the case of LGBTI rights, I do remember there was a decision given by the Supreme Court in 2015, ruling the same-sex marriage as legal right across the US, based on the constitutional protection of equal dignity. So I do remember that Professor Daniel could have those numbers better than I do, but out of 50 states, more than 36 protected same-sex marriage. Then we have the decision given by the court, the Supreme Court, and again, we have the response of the legislator about, as you mentioned, interracial and same-sex marriage. That you raise, on one hand, brings this dynamic. Who has the last word in a democracy? Is the legislative branch? What would be the scope of judicial review given by the Supreme Court? So you have all this, I'd say, checks and balances, considering the federal clause and the separation of powers. And then you have another that you mentioned, the international arena. And in your question, you focus on the inter-American system or the UN system. So at the inter-American system, we have this human rights game, I'd say. What is the game? The game is, the idea is that in the exercise of the free, in the free exercise of sovereignty, states like Brazil ratified the American Convention, recognized the Inter-American Court. Is not the case of the US. The US just signed the American Declaration as Canada. So just a footnote, we have three different regimes at the OS. We have states such as Canada and the US, and they just signed the American Declaration. But even though they just signed, the Inter-American Commission has a mandate to monitor and protect and promote rights legally based on the American Declaration and the OS Charter. The second regime is that there is a number of states which signed the American Declaration, ratified the American Convention, but do not recognize the jurisdiction of the Inter-American Court, such as Jamaica. So, for example, I would like to share with you, as a former rapporteur of LGBTIs, I gave priority to two leading cases against Jamaica concerning criminalization of LGBTI persons. So we adopt the merit report, two merit reports about dramatic situation of the, I'd say, the appliance of those laws. And that's over because we cannot submit the case before the Inter-American Court because Jamaica does not recognize the jurisdiction of the court. And there are, I'd say, there are the other, the third regimes, like in Brazil, Argentina, Chile, Colombia, Ecuador, and others, a group of states which signed the declaration, ratified the American Convention, and do recognize the jurisdiction of the Inter-American Court, just to clarify this. But what I would say that we have the case system, so according to this rationality that the state, in the free exercise of its sovereignty, ratified the American Convention, so the state agreed to play fairly the game of legal duties and rights, and accept the international accountability concerning the way the state respect human rights. So we have a toolbox at the Commission which comprehends public hearings, the case system, precautionary measures in case of gravity, urgency, and irreparable damages, and in-loco investigation, and letters to states. So we have a number of tools, and the Inter-American Court has advisory and contentions jurisdiction. So I'd say that through the case system, we could have we could have a sentence, for example, if the state recognized the jurisdiction of the court, condemning the state to take all the measures to I'd say, to harmonize the internal arena towards the inter-American standards, because this is something important concerning the American Convention. Look at Article 1 and 2. The first article provides that all states shall guarantee, without any kind of discrimination, all rights provided by the Convention. But Article 2, the second article, demands the state to adopt all measures to apply the Convention and the inter-American standards. So we have the idea of conventionality control. And I could explore this more in other questions if there are any interest about that. But anyhow, so we have, yes, we have an horizon of the, I'd say, of a transformative incidence of the inter-American system. But let me be clear with you. I would say that the decision is not an end of the process, is the beginning of another process, that is the political process of implementing the decision in the state. So that's my view. Thank you so much. Such a fascinating question. Thank you.
Thank you. If I may just add one point to this, I think it's worth pointing out that US constitutional law is grounded in a very old constitution with a very small, simplified toolbox, which is substantive due process. And that is part of the conceptual advantage of studying systems like human rights, and particularly the regional developments. You get more sophisticated tools to approach these questions. Sometimes I think that the US constitutional system is like trying to build a modern building with only hand tools, no power tools. And so you get better ways of thinking about these things, like you were talking about use cogents and so forth. So that's part of what's going on, I think, in the dissonance between some of the US constitutional discourse and what's happening in many places around the rest of the world. There's just been a lot of evolution of legal thinking in the last 200 years. Anyway, let's take a question from the Q&A. Tim, you want to read
Professor
it?
Daniel, just a footnote, if you allow me.
Please.
Really interesting what you just said. And I'd just like to add to my previous answer. There is one mantra of the Inter-American system, and I'd say the European system as well. Both courts say, oh, this document, the American Convention, is a living instrument.
Yeah.
Is a living instrument. So, for example, this living instrument shall address digital rights, shall address trans persons' rights, shall address business and human rights, climate change, by this progressive way of interpretation of reading the convention.
Yeah.
Just this footnote. Thank you.
Thanks. So the next question is from our co-director, Professor Brenton Likes, who's on Zoom. And she says that although you only mentioned religion explicitly in your presentation near the end, she wonders how you might characterize the relationship between LGBTQI+ issues and Catholicism and Christianity in the region, and in particular, in light of your work and your presence on the faculty of a Catholic university. Do you experience tensions, contradictions, et cetera, vis-a-vis these positionalities?
That's a great question. Great question. Is a question for another talk. But anyhow, three brief thoughts. Again, I'd like to emphasize the idea that equality and non-discrimination for the Inter-American system and for the Inter-American Court is a peremptory norm, is part of use cogents. The second idea, and I'd like to say thank you to this invitation because allow me to update myself. And I was yesterday with my former staff of the rapporteurship, updating my talk for today. And I learned that April last year, the Inter-American Court issued a very interesting case called Case Piovesan against Chile. What was the situation? There was Sandra Paves, who is a lesbian, and she was a professor of Catholic religion in a school. And then there was a debate that because of her sexual orientation, she was not allowed to give lessons in class about Catholicism. And the Supreme Court of Chile endorsed this view. And finally, the case was brought before the Inter-American Commission and then before the Inter-American Court, and the court condemned Chile. And the argument was that there was a violation of her intimacy and especially equality and non-discrimination. So this is a very interesting case that I'd like to share. I didn't read all the pages of the sentence, but it's a very interesting case. And third, what I learned, even looking at Catholicism and at the evangelics, Catholics are not homogeneous. Evangelics are not homogeneous. For example, I am a professor at Catholic University of São Paulo, and there is a group of Catholics for free choice in my university. So I think this is important to say. And I do remember just that's I'd say a very strong memory that I have, a mission that we had to the Vatican. I was representing the Inter-American Commission. There was one representative of the UN and of Oxford as well. There was a judge of the Commonwealth. There was a judge a former judge of the Supreme Court of Australia, and we were sharing. The idea was to have a public hearing with the Pope, but the second of the Vatican received us, and we were presenting a report about how laws which criminalize LGBTI rights implies and creates a room of hostility, discrimination, and violence against LGBTI rights. And the response of the Minister of International Affairs of the Vatican was that according to Catholicism, everybody is created according to the light of God. The Catholicism cannot accept those kind of suffering. And finally, if those laws bring suffering, so they violate human dignity. It took time, but last week, when the Pope was in Africa, he said, it was a little bit a paradox, but he said, oh, LGBTI rights are a sin, but at the same time, you have to respect. So it was a kind of puzzle, but anyhow, that was the idea, although it took time. So those are the lessons that I learned. And this is something really challenging, how to do with highly conservative groups, Catholic, evangelics, remembering always emphasizing equality and non-discrimination, and taking into account that they are not homogeneous at all. So thank you.
Well, thank you. I think we don't really have time for another question unless we have a brief one. We only have like 3 more minutes. Go ahead. Can you just shout it out?
Professor Piovesan, considering the importance of the cases you mentioned today, the importance of jurisprudence, I would like to know how to spread the jurisprudence among the inter-American system so that it became very well known for all. Okay.
Can you hear that? How do we disseminate these ideas that are germinating in the inter-American system so they have more force and more life?
Herbert from Brazil.
I love this question.
From another Brazilian.
I love my Brazilian colleagues. Thank you for all the support. I love your question because this is my mandate now in Brazil, I would say. For example, at the National Council for Human Rights, we adopted last year, the president of the Supreme Court, the National Pact of Judiciary for Human Rights. And one of the programs is exactly to foment capacity building programs on conventionality control and inter-American jurisprudence. There is a recommendation 123 of last January, adopted by the National Council for Justice, recommending all judicial branches in Brazil to adopt international treaties, to apply inter-American jurisprudence, and to exercise conventionality control. So this is an example. I myself, as a professor of PUC, São Paulo, I will start in 2 weeks after Carnival here in Brazil. Everything starts after Carnival here. A master's program, a discipline called the transformative impact of the inter-American system, for example. So I think we have different ways and strategies to disseminate the transformative impact of the inter-American system. And being here I feel delighted because it's a very, very powerful, I'd say, space to spread those ideas and to protect human dignity and to prevent human suffering. Thank you so much.
Well, I think maybe also a good way to do it is to bring you here in person as soon as we can, so we can have more seminars and discussions. Let me just thank you again for your fantastic talk and your generosity, and to wish you safe travels. I know you said you're going to the Amazon region. So we hope to see you soon in Boston in good weather and with food, and we'll continue these conversations then. Thank you so much.
Thank you so much, Professor Daniel. With all witnesses, I keep so glad this offer and this invitation. I kept this, and now I'm going to Amazon region to do a capacity building with indigenous leaders. So in the use of the Inter-American system, by the way. So thank you for this wonderful invitation, and count on me. We are together for this great cause.
Safe travels.
Bye.